This is Barry Zalma on Insurance. I am an attorney who has retired from the active practice of law and now spend my time acting as an insurance claims consultant, an insurance claims expert witness, and author and producer of these videos. Today, I'd like to talk about the trigger of coverage for property damage claims. The term trigger of coverage means, quote, what event must occur for potential coverage to commence under the terms of an insurance policy, close quote, and, quote, what must take place within the policy's effective dates for the potential of coverage to be triggered. This is a case called Re Feature Realty Litigation, a 2006 case from the Eastern District of Washington. After the California Supreme Court adopted a continuous trigger of coverage in a case called Montrose Chemical Corp versus Admiral in 1995, in the case of successive policies, property damage that is continuous or progressively deteriorating throughout several policy periods is considered potentially covered by all the policies in effect during those periods, so that the insurer's duty to defend arose under those policies. Insurers, trying to limit their coverage, revised the policy wording. Therefore, the precise question is what result follows under the language of the policies of insurance to which the parties agreed. The continuous injury trigger has been applied mostly in cases involving gradual release of pollutants and other environmental harms. After Montrose, the insurers revised their policies to use the language for the very purpose of obviating the application of the progressive damage continuous trigger articulated in Montrose. As a result, the defendant's policies now state that property damage, quote, which commenced prior to the effective date of this insurance will be deemed to have happened in its entirety prior to and not during the term of the insurance, close quote. See Insurance Company of Pennsylvania versus American Safety Indemnity Company, a 2019 case of the Court of Appeal of California. In King County versus Travelers Indemnity, the Western District of Washington in 2019 found that the Louisiana Court of Appeals had ruled that allegations by a property owner that an environmental consultant failed to detect the presence of pollutants on its property did not trigger coverage under the consultant's liability policies. The court found that the occurrence giving rise to the claims against the insured took place years before to the issuance of the policies in question. Reaching a decision that comports with that of a majority of the states, the Louisiana court said, quote, in order for there to be coverage under these policies, the property damage must have occurred during the policy period. The property damage was the contamination of physical injury to the property, which was caused by previous owners and users of the site. GTL's liability is hinged upon its failure to detect the contamination. Even if the property is not considered physically injured, property damage as defined by the policy includes loss of use of tangible property that is not physically injured. However, that loss of use is deemed to occur at the time of the occurrence that caused it. That occurrence predated the policy by almost 7 years. Accordingly, the property damage did not occur during the policy period and coverage is unambiguously excluded." Close quote. Whenever a claim is made for damage to property, it is essential that both the insurer and the party making the claim determine the date and time when the property was actually physically damaged. Claim should then be made only to the insurer that was on the risk, the one whose policy was in force at the time the physical damage occurred, not the one whose policy is in force at the time suit is filed. While the term trigger of coverage is not a term used in an insurance policy, it is, as the California Supreme Court said, a convenience used to describe that which, under the specific terms of an insurance policy, must happen in the policy period in order for the potential of coverage to arise. The issue is largely one of timing. What must take place within the policy's effective dates for the potential of coverage to be triggered? This is Montrose Chemical versus Admiral in 1995 and State versus Continental in 2012. Because occurrence policies, as distinguished from claims-made policies, cover occurrences that result in injury during the policy period, the courts in California and elsewhere have concluded that the policies are invoked or triggered when the injury takes place. The word trigger, as a term of art, means the event that activates coverage under one or more insurance policies. The trigger of coverage problem arises in determining exactly what must take place within the policy's effective dates to trigger coverage. Different states apply different triggers of coverage theories, including the manifestation trigger, the exposure trigger, the continuous trigger, and the injury in fact trigger, recognizing the existence of various triggers of coverage. No Texas state appellate court has discussed which trigger of coverage theory should apply to a first-party claim under a standard homeowner's insurance policy based on continuing or progressively deteriorating damage to the insured's dwelling. When the Travelers issued a policy that provides coverage for injury or damage that happens while this agreement is in effect, it limited its coverage to that temporal requirement that applies only to the injury that occurs while the policy is in effect. Travelers bargained for an injury-based trigger of coverage, not an act-based trigger. Under the policy's plain terms, Travelers must defend any claim in which covered injuries occurred during the period when its policies were in effect, regardless of when the wrongful causal act occurred. This was Travelers versus Mitchell, a Fifth Circuit case in 2019. Therefore, when dealing with a continuous injury to real property, it is necessary to first review the policies in effect at the time the injury was claimed to have occurred, determine exactly when the damage actually happened, apply the language of the policy wording to the facts determined, and then find out what the law of the state where the injury occurred is and how that law applies which trigger of coverage before even considering making a decision whether to accept or reject a claim. This video was adapted from my book, Zelma on Insurance Claims, Part 102, Second Edition. available as both a Kindle book and as a paperback from Amazon.com, and is part of a 10-volume set of Zalma on insurance claims. It is also available with detail from Zalma.com by clicking on the Insurance Claims Library. Please, if you found this interesting or useful to you in your profession, refer it to your colleagues. And if you wish to learn about more of my blogs and my videos, please subscribe to my blog at zalma.com/blog. Thank you again for your attention.